Lady, my Lords, good morning. Can I begin by explaining that I propose to make my submissions in the following order. Firstly...
Would you mind speaking up a bit? I'm sorry, it's quite a full court and the sound system is not quite as strong as it might be.
Firstly, I propose to look at the nature of the sentence that was imposed on the appellant in this case.
Thank you.
An extended sentence. And in doing so, I'll seek to identify the differences between an extended sentence and an ordinary determinate sentence. Secondly, I shall look at what the case of Khayyam, Haney, Massey and Robison decided and seek to identify the principles underpinning that decision. And then thirdly, I hope to explain why I see the implied ancillary duty arising under Article 5 of the Convention, that is the duty to facilitate release of a prisoner, is one that applies to the appellant, because as I'll come on to submit, the principles and reasoning that the court applied in Khayyam are equally applicable to someone who is in the appellant's position in September of 2010, that of a recalled extended sentence prisoner who had served 2/3 of his sentence and at the time of his recall had passed the point of mandatory release. Thereafter, I propose to deal with the alternative argument advanced on the appellant's behalf, that is, that the ancillary duty to facilitate release applied to him because the stage at which his sentence had reached. And then finally, I propose to deal with the issues raised by the respondents in their cross-appeal with regard to the award of damages that would be appropriate in this case. So my starting point is to look at the nature of the sentence imposed, and of course the nature of the sentence and the full chronology relating to that has been explained in the chronology attached in the appendix, and of course the written submissions that have been lodged by parties. But just to summarise, the appellant was aged 16 when he committed the offence of culpable homicide, and in respect of which he was sentenced to an extended sentence of 10 years. The sentencing judge set the custodial part of that sentence at 7 years and the extended period at 3 years. The sentence was backdated to August 2005, so that the custodial part of the sentence ran from that date to August 2012, and the extended period thereafter ran to the end of August 2015. The power to impose an extended sentence was conferred by Parliament by virtue of the Crime and Disorder Act 1998, and the provisions for that sentence in Scotland are contained in section 210A of the Criminal Procedure Scotland Act 1995. It is a sentence that's available to the sentencing judge where it is considered that the period in respect of which the offender would otherwise be subject to licence would not be adequate for the purpose of protecting the public from serious harm from the offender. This type of sentence was described by Lord Carloway in the case of Ferguson against Her Majesty's Advocate, 2014 Scots Law Times, page 431, and it is referred at pages 2 and 3 of the appellant's written case, which is at the core volume and is at pages MS 93 and 94. Paragraph 5 refers to Lord Carloway's judgment in Ferguson, and it is helpful in the sense that it just sets down there for us and easily accessible the terms that we are dealing with.
Thank you.
And perhaps the court could just be reminded that Lord Carloway, looking at the provisions, if you look at the top of page MS 94, explained that it's the selection of an appropriate penalty in which the judge will have regard to societal needs for punishment, deterrence and protection of the public, and rehabilitation of the offender may play a part in this exercise. And at paragraph 4, Lord Carloway went on to say the court was given a discretion to impose a period of post-release licence in respect of any sex offender convicted on indictment and any person convicted of a violent offence for which the court intended to impose a custodial term of 4 years or more. He went on to say, for present purposes, the significant features are that the imposition of an extended sentence is discretionary and it can be selected if the court considers that the period, if any, for which the offender would, apart from section, be subject to a licence would not be adequate for the purposes of protecting the public from serious harm from the offender. Lord Carloway explained that the practical utility of the extended sentence was and is to allow the court to increase the period during which the offender may otherwise have been on parole and thus subject to supervision with the prospect of his licence being recalled. Thus, I would say that an extended sentence is a sentence that is preventive in nature. It is a sentence in which the sentencing judge expressly selects a period of extension of detention that is justified solely by reference to public protection. And it exposes a convicted person to the loss of his liberty for a period that could be as long as 10 years because of the risk of what he might do. And I say that an extended sentence differs in characteristics from the normal type of determinative sentence. As I say, it is preventive in nature and permits the sentencing judge to predetermine the period of actual custody along with a period of compulsory supervision in the community.
Up to a point, because obviously the parole board could authorise release after half of the period of the, in this case, the 7 years, or failing that, there would be automatic release after 2/3 of it had been served. So the gap between a half and 2/3 depends on the parole board's assessment of risk.
Yes, it does. But at the stage of, for example, a recall prisoner, the risk is also the basis upon which the decision is made whether or not to release the prisoner. So risk features and the questions of public protection feature in the administration of the sentence, but particularly at the point of mandatory release, when someone's free to be released into the community, and if they're recalled in licence, they're called back to prison, serve perhaps the remaining of the custodial period, but are also exposed to that period of extended licence for which they remain in custody until the parole board is satisfied about their level of risk. So my point is it's different in the sense that there is a period within the sentence imposed by the sentencing judge that is specifically identified as relevant to public protection, separate to the custodial period that the judge has identified should be served as the punitive element of the penal element of the sentence. So I say that there is a distinction between the extended sentence and an ordinary determinate sentence. And it's that at a determinate sentence, the court passes a sentence of imprisonment for a period of time, and the executive has the power to allow release from the detention imposed by the court on the basis of mandatory release, or indeed the parole board has the power to authorise release on a discretionary basis. However, in the case of an extended sentence, the court has imposed a specific period of imprisonment and a period where the offender will be on licence. That period of licence can be converted by an executive decision into imprisonment, which is thereafter administered by the parole board. So I make the point that the custodial term is imposed by the court, and once the custodial term has passed, no court sentences the offender to imprisonment. What has been done is to authorise him to be imprisoned if his licence is properly revoked. So my position is that that very much puts an extended sentence into the category where there may be a substantial period in the sentence for the protection of the public, during which there may be need to make further assessments of the prisoner's degree of risk and whether or not his risk is reduced to a level that permits his release into the community. A helpful analysis of what an extended sentence is and how it compares with an ordinary determinate sentence is contained in the case of Sim against the Parole Board, and that is in Volume 3 of the Authorities at tab 22, and the MS page number is 1257. Just while the court calls that case
1257.
1257.
Thank you very much.
Tab 22
Yes.
in Volume 3.
Thank you.
I can summarise the case by explaining that the principal issue that was raised related to how Article 5 of the Convention affected the detention of an offender who had been recalled to custody while on licence under an extended sentence passed under what was then Section 85 of the Powers of Criminal Courts Sentencing Act 2000. The provisions of that Act are in Volume 4 at MS 1438. I wouldn't propose to look at these because although they're slightly different to what is now contained in the provisions for an extended sentence, the manner in which the extended sentence operated was very much the same. The Court of Appeal held in this case that where an offender is detained during the extension period of an extended sentence, that his detention required to be subject to review by a judicial body because no court had ordered his detention during that period, as prima facie, the sentencing court had taken the view that he could be dealt with in the community. To go quickly to the court's summary of the court's position at appeal, I would refer to paragraph 36, where the court summarised our position.
Yep.
It's at page MS 1302.
Thank you.
Oh, excuse me. Yeah, and it's paragraph 36, where the court said, in short, where an offender is detained during the extension period of a Section 85 sentence, such a detention must be subject to review by a judicial body. No court has ordered his detention during that period. Prima facie, the sentencing court took the view that he could be dealt with in the community during that period. This is the critical factor which distinguishes this situation from that considered in Giles and Smith, in both of which the court was concerned with detention falling within the term of imprisonment imposed by a competent court. In cases of extended sentences under Section 85, it is the executive which decides upon an offender's recall during an extended period, and because that detention has not been ordered by a court, it must be supervised by a judicial body. Otherwise, there's a danger of an arbitrary decision being made by the executive. As it happens, it is so supervised because Section 44A of the 1991 Act so provides through the mechanism of the Parole Board. Parliament was right to take the view that such judicial supervision of detention during that period was necessary, and I conclude that Justice Elias was right in the conclusion which he reached on this issue. The rationale for the court's opinion is really to be seen from paragraph 32 onwards, which begins at I need not take the court through that in detail at the moment, but it's safe to say that in reaching the decision that it did, the Court of Appeal, in deciding this issue, took full cognizance of the jurisprudence from Strasbourg and the decision of Giles against the Parole Board.
Right.
And that can be seen in detail if one looks at MS page 1300 and MS page 1301.
Thank you.
And over that there's full discussion of the cases from Strasbourg, full discussion of the Giles case, and in some detail a discussion of the decision in the Van Druvenbroek case, which Lord Hope looked at in detail in the case of Giles. And when I come on to my alternative argument, I will be looking in a little detail at the Strasbourg jurisprudence. But for my purposes at the moment, just in looking at the nature of the extended sentence, I'm happy just to direct the court to the summary of what the Court of Appeal said. Now, in relation to the case of Sim, I note that it was a case decided in 2004, and it was a case decided before the more recent developments in our law, and particularly the decision by this court in the case of Cayenne. I note that the ratio of the case would appear to limit the operation of Article 5.4 to an extended sentence just to the time of the extension period. And I recognise the case requires to be seen in that light. However, I would respectfully submit that the way that which the courts now view the operation of Article 5.4 has changed somewhat, particularly with the recognition that was described by the court in the case of Cayenne of the need to start at the progression of a prisoner before tariff expiry, and the need to identify that the prisoner has a reasonable opportunity to rehabilitate himself and to demonstrate to the parole board that he's reduced his risk to a manageable level. And consequently, I reasonably would suggest that given Article 5.4 is identified as applying during the extension period, it would be reasonable to conclude that Article 5.4 should apply at an earlier stage, and at the point at which this should occur, I would submit, is where an extended sentence prisoner is recalled to custody.
I wonder if another way of looking at it might be to say that Article 5.4 is concerned with the need for detention to be subject to judicial supervision that hasn't actually been imposed by a court, and that's what SIM is about. The problem that arises in the present case might be said to be that if rehabilitation is one of the essential aims of the detention of somebody in the circumstances of the appellant, then the absence of any facilities for rehabilitation renders his detention arbitrary in terms contrary to Article 5.1.
In the sense that it would be unlawful detention in the way that the European Court approached it.
Yes, it would be in violation of Article 5.1.
Yes, yes. That is so, Lord. In any event, in Scotland, where an extended sentence prisoner is recalled to custody, his case is referred to a parole board, and whether he's granted release is determined by a review by the Extended Sentence Prisoners Tribunal. And the way in which his sentence is administered doesn't depend on whether he's still serving part of his custodial sentence imposed by the court. His release now depends on whether he can demonstrate that his level of risk is at an acceptable level, and that remains the position through until the end of the extended part of his sentence. And when deciding whether to release the prisoner, the Extended Sentence Prisoners Tribunal applies the test set down in Section 3A4 of the 1993 Act, which is referred to at length in the written case. And the test that the parole board applies is whether or not it's satisfied that it's no longer necessary for the protection of the public from serious harm that the prisoner should be confined, but no other. But in that situation, if that level of harm isn't met, his release should not be directed. So I say that in this case, the appellant was granted mandatory release and recalled to prison at a stage where he still had some part of his custodial sentence to complete. And following recall, the decision as to whether or not he was released was in the hands of the Extended Sentence Prisoner Tribunal. The test that applied throughout his period of detention following recall related to risk, and thus was a period during which new issues of lawfulness may arise in the course of his detention. And I say, following on the analysis in Sim, that Article 5.4 in this case applied to the appellant. So my next point is what the case of Khayyam held and where it identified the duty was located in terms of the Article 5 and why that was so. In all the written submissions that are before the court, parties have made extensive reference to the case of Khayyam, as of course it was a case in which this court explained the ancillary duty in the state implicit within the scheme of Article 5 to facilitate a prisoner's release. It was, of course, a case that dealt with IPP sentences, and it was a case in which the court also explained why the same duty would apply to life sentences. These, of course, are both indeterminate sentences. And, of course, I accept that the court in Khayyam did not deal with a case such as this, a recalled extended sentence prisoner. However, it's my respectful submission that when one understands the reasoning that underpinned the decision in Khayyam, the same reasoning, the same principles apply to a prisoner such as the appellant.
Can I
Yes.
interrupt just for a moment, just before we've forgotten about Sim? I noticed that the legislation in issue in Sim, Section 85 of the English Act of 2000, says in terms that the purpose of imposing extended sentence is the purpose of preventing the commission by the prisoner of further offences and securing his rehabilitation.
Yes.
Now, those words, the final words, are absent from the Scottish provision.
Yes.
And I don't know if anyone knows if there's some identifiable reason for the omission from the Scottish legislation of the reference to rehabilitation that one finds in the English provision.
Well, I'll see if I can identify that for my Lord. But one would see the date of that legislation, and one would understand, as we'll come on to see, the law has significantly developed in the context of the way in which prisoners' sentences are administered and the real understanding of the need for rehabilitation having been identified in many ways. And indeed, what I did refer to at the outset was what Lord Carloway said about the purpose of a sentence, which would include in part rehabilitation, so perhaps it wasn't felt necessary that that would be spelt out in terms. But I'll see if I can identify from the legislation and the background to that why that might have been. So the position that the appellant was in was that he is in custody for public protection following his recall, and in order to secure his release, he would like to require to demonstrate a reduction in risk. He has regular reviews at the Parole Board where they identify coursework that he has to undertake in order to satisfy their concerns over risk. And the respondents and interveners in this case assert that the case of Khayyam has restricted the implied ancillary duty, and that it would be wrong for this court to recognise a similar duty applicable to the appellant. However, I would submit that the duty in Khayyam was identified and developed by this court, as I say, on the same principles that are engaged for recalled extended sentence prisoners. And I propose to refer in short to certain sections of Khayyam, which is contained in Volume 3 of the Authorities, tab 20.
Thank you.
And the page number is MS 1136. At page 1369, which is MS 1161.
Yes.
At paragraph 36, a I say it's instructive to note that the court explained that having identified that the fourth section underlined the link which should be recognised between preventive detention and rehabilitation, and explained that there was an individual remedy in damages under the Convention for failure to provide prisoners serving indeterminate sentences with proper means of protection. It accepted the fourth section's conclusion that the purpose of the sentence includes rehabilitation in relation to prisoners subject to life, in respect of whom shorter time periods that the Supreme Court can and should accept as the state was under a duty such a prisoner to rehabilitate demonstrate that he no longer presents a danger to the public. But we do not consider that this duty can be found in the express language of Article 5.1, treating it as an aspect of the duty to avoid arbitrariness under Article 5.1 has unacceptable and implausible consequences, which we've already identified. At paragraph 13 of the case, at page 1360, MS 1152, the Supreme Court also explained that whilst this case, the James case, didn't concern life prisoners, it was clear from cases decided under Article 5.4 that it would adopt a similar reasoning. And at paragraph 13, explained why that should be. And there was reference to Lord Reid's decision in Sturman. And at paragraph 13, it goes on to say that since the need for public protection was likely to change over time, discretionary life prisoners whose tariffs had expired were entitled to invoke Article 5.4. So the fact that Article 5.4 what could be invoked was important in the court's assessment as to whether or not an implied ancillary duty should be applicable to a certain type of prisoner. Looking to locate the duty within Article 5 then, where it wasn't within the express language of the article, at paragraph 37, MS page 1161, the court went on to explain that Article 5.4 gives rise to an ancillary duty on the state, breach of which does not necessarily impact on the lawfulness of the detention. The duty is to make available access to judicial review by a court or here the parole board, which would consider whether information put before it justifies continued detention. It went on to say speedy access to the parole board, like reasonable access to proper courses and facilities, represents an important aspect of the prisoner's progression towards release. But the language of Article 5.4 is in terms confined to access to judicial review by the parole board on the basis of information available from time to time. It doesn't cover the prior stage of provision of courses and facilities in prison, which gives rise to the information necessary on any parole board review. And looking down to paragraph 38, the court went on to explain the duty to facilitate progress of such prisoners towards release by appropriate courses and facilities cannot therefore be brought within our opinion within the express language of 5.4, but it's on any view closely analogous at an earlier stage to the duty involved under Article 5 as an analogous duty arising by implication at an earlier stage than that covered by 5.4, rather than to treat 5.1 as incorporating it. So for my purposes in looking at these paragraphs, I would respectfully say that it is significant that the Supreme Court recognised that it is a combination of factors, access to the parole board and access to rehabilitative courses, that are of equal importance, and one without the other does not facilitate progress towards release. Thus, along with the requirement for review within 5.4, Sensibly, within the scheme of Article 5, the court recognised an implied duty to facilitate the prisoner's progress towards release, which would include the provision of coursework and other facilities. The content of the duty is described at paragraph 41, and the court identified that it is a right that arises in relation to each individual prisoner, and it is the question of whether or not it arises is highly fact sensitive, and it wouldn't be necessary for a prisoner to be able to demonstrate that there had been a systemic failure so to satisfy the Wednesbury standard of reasonableness. At paragraph 19 and 29 of the appellant's written case, at pages MS 98 and 99, and MS 103 and 104 respectively, the appellant has set down what factors were of significance and influenced the Strasbourg Court and the Supreme Court in reaching the decisions that they did in relation to James and Kyan. Dealing with the case in James, I go to paragraph 19 of the written case and arguments. To MS 98 and 99. I would just refer the court there to the summary that the appellant has provided in relation to the factors that the appellant suggests influenced the Strasbourg Court in relation to the decision that they made in James. And I would just summarise, without reading in detail, that the court looked at the detention and particularly identified that a concern would arise where someone was serving a punishment element of their sentence and they're in detention, who, having served a punishment element of their sentence, were in detention solely because of risk. The court looked at over page 99, MS 99, the court looked at the purpose of the detention at paragraph 205 and stated it was necessary to identify the purpose of detention in order to consider arbitrariness. At paragraph 205, the court also looked at whether or not the detention included in part the rehabilitation of offenders. The court also looked at the international law in respect of prison regimes, and thereafter in MS page 100, the fact that the government sought to rely on the risk posed by offenders to the public in order to justify continued detention. And in that situation, the court said regard had to be had to the need to encourage rehabilitation of those offenders. And finally, MS page 101, there was a settled understanding of how matters would work in practice, which was that rehabilitative coursework would be provided to IPP prisoners. These were the features that weighed heavily on the Strasbourg Court decision in James. And at paragraph 29, at MS page 103, the appellant summarises the factors that it was respectfully submitted were considered as appropriate, as important, when the court decided as it did in the case of Kaya. The appellant summarises features of the case that apply to his case just as equally as they apply to the appellants in the case of Haley. First of all, the fact that he was a recalled extended sentence prisoner. After the expiry of the custodial term of his extended sentence, he was detained for that period, which on statute can be up to 10 years. In order to secure his release from detention, he would have to appear before the parole board and demonstrate a reduction in his risk. He would have to have completed rehabilitative coursework, because that's a central element of the extended sentence prison tribunal assessment. It's also the case that the international law in respect of prison regimes applies similarly to him, and the practice of the state at that stage was to provide rehabilitation to all categories of prisoners without any difference in terms of how that policy was operated. So these points that I make are summarised on page 12 through to 13, MS page 103 to 104. So looking now to the decision of the Inner House, the Inner House rejected the appellant's case, and doing so explained their reasoning at paragraphs 34 to 50 of their opinion. And in summary, they referred to the critical difference between determinate and indeterminate sentences, and concluded that an extended sentence was properly classified as a determinate sentence because at the end of any determinate sentence, the prisoner must be released, even if he was considered a threat to public safety. This was the Inner House's explanation for not applying the ancillary duty, that the sentence in this case was not an indeterminate one. I respectfully submit that this was the wrong way for the Inner House to have approached the matter. It ignores what the purpose of the sentence was and fails to look behind the label attached to the sentence and at the reality of the situation. It's also the case that the implied ancillary duty does not depend on lawfulness, but focuses on the purpose of the sentence and whether or not it includes rehabilitation. Further, I would submit that there's no fundamental difference between prisoners who are serving a period of an indefinite sentence and those serving, for example, a period of detention imposed by the court in respect of their offence and being held for the purposes of public protection for up to 10 years. I respectfully submit that it is not a satisfactory argument or analysis by the Inner House if, in fact, at the end date of a prisoner's detention is reduced if rehabilitation is afforded and the prisoner can demonstrate a reduction in his risk. I say that in my submission there's no principled distinction between a prisoner serving an indefinite sentence and an extended sentence that can be up to a period of 10 years. Now, the respondent's argument rejecting the application of implied duty by reason of this type of sentence being determinative, I say is at its weakest when they say the implied ancillary duty applies to some sentences that are preventative and for the purposes of public protection and not for others. And insofar as when the duty arises, I respectfully submit it arises to a recalled extended sentence prisoner at the stage of recall. Such a prisoner is required to serve the remainder of his custodial term and the extended period of licence, and will only be released by the parole board if they have demonstrated the reduction in their risk. So one can see why, when one looks at the analysis of Article 5 and the way in which the implied ancillary duty was created, that it very much recognised the combined factors of the need for rehabilitation and for judicial review of detention, why one can see fundamentally that this is a case where there's no difference in principle in respect of the appellant's position to that of the prisoners who are serving other types of preventive detention. I then move on to my alternative argument.
Well, I'm sorry, before you leave that argument, there's quite a lot of Strasbourg authority to the effect that all prisoners should be offered the opportunity of working towards rehabilitation.
Yes, I appreciate that.
I'm not sure that any of it's referred to by the Inner House. Are you going to be placing it before us?
It is discussed in the minister's case, and it is before the court, and I recognise that Strasbourg jurisprudence identifies the need for rehabilitation, and indeed the recent cases in that regard are before the court and are relied on by the ministers in support of their argument that the need for rehabilitation is not a duty imposed on the state, but it is something that the state take into account in the administration of a sentence before, during a prisoner's release. But I see that as a separate issue to the question of the duties that apply to the state when a prisoner is in protective custody, is serving a preventative sentence for the purpose of public protection. I can show my Lord where the ministers make reference to the rehabilitation cases.
Yes, I've read that case.
Yes.
I was just wondering if you were not going to be relying on any Strasbourg authorities.
I am going to come on to look.
Oh, you are going to.
Because it really is in the context of the alternative argument that I'm going to look at some of the Strasbourg cases. The alternative argument advanced on behalf of the appellant is that the duty arises because of the stage that his sentence is reached. The appellant has passed the point of mandatory release on licence, and the basis for any later recall to prison and detention would only be the risk of his reoffending. I see, therefore, he's in an analogous position to that of an indeterminate sentence prisoner and has an Article 5.4 Convention right to bring proceedings for judicial review of his sentence under Article 5.4 of the Convention. In that situation, and understanding rationale in Cayenne as to the reason for the implied ancillary duty, which at paragraphs 37 and 38 very much links two factors in respect of the duty to facilitate release, which I refer to, the provision of coursework and facilities in prison, which give rise to the necessary information for a parole board review, and the fact of the Article 5.4 review itself, I say it's only logical that the same duty applies. If there's no provision for coursework or facilities that provides the prisoner with reasonable opportunity to rehabilitate himself, then the exercise before the parole board becomes an empty one. And it's logical because it's recognised that access to the parole board and access to rehabilitative courses are of equal importance, and one without the other does not facilitate the prisoner towards release. It's my submission that both our domestic law and the Strasbourg jurisprudence support the analysis that 5.4 applies. This is looked at in the appellant's written case at pages 15 through to 24. And in this regard, I would wish to rely on, firstly, the authority of Giles against the Parole Board, which is in the authorities of Volume 2.
Yep.
Tab 17, MS 985.
Sorry, could you repeat that? There was a lot of banging going on, so I couldn't hear.
Volume 2, Tab 17, MS 985.
985, thank you.
And in this regard, I rely on what happened was that the original court had passed a determinate sentence of imprisonment, albeit it was for a longer period than the commensurate term, and it was a case in which the prisoner had not advanced his sentence beyond the halfway term, and the court was being asked to determine whether his continued detention required further reviews under Article 4. Lord Hope undertook a review of the Strasbourg jurisprudence at paragraphs 27 through to 51, and at paragraph 51 set down what he described as a basic rule and identified circumstances where the rule was to be departed from. Paragraph 51 is at page 34 of the judgment at MS 1018. This simply summarises the analysis that Lord Hope went through before reaching these conclusions, and explained that it was plain from the summary that the basic rule which the European Court laid down continues to apply. And where a prisoner has been lawfully detained within the meaning of Article 5.1, following the imposition of a determinate sentence after his conviction. The review which Article 5.4 requires is incorporated.
I'm sorry, would you mind speaking up? Either going close to the microphone. It's not, the arrangements aren't perfect, and at times your voice is difficult to hear.
Yes. It says, once the appeal process has been exhausted, there's no right to have the lawfulness of the detention under that sentence reviewed by the other court. It says the principle which underlies these propositions is that detention, in accordance with a lawful sentence passed after conviction by a competent court, cannot be described as arbitrary. The cases where the basic rule has been departed from are cases where decisions as to the length of the detention have passed from the court to the executive, and there is a risk that factors which inform the original decision will change with the passage of time. In those cases, the review which Article 5.4 requires cannot be said to be incorporated in the original decision by the court, and a further review in judicial proceedings is needed at reasonable intervals if the detention is not at risk of becoming arbitrary. So, in this particular case, the court looked at a general rule and an exception where the decision as to the length of detention passes from the court to the executive, and the court particularly looked at the fact that the European jurisprudence required one to look behind the label applied to a sentence and to understand what in practice was actually happening. And at paragraph 40, Lord Hope looked at, in particular, the case of Van Drugenbroek and identified that there was an important point that emerged from the decision in Van Drugenbroek. Because Van Drugenbroek was a case in which the prisoner had been sentenced to a discretionary sentence of which had a 10-year and to understand what was actually happening in practice. In paragraph 40, what the court said was that an important point that emerges from these two decisions for present purposes is that a distinction is drawn between detention for a period whose length is embodied in the sentence of the court on the one hand, and the transfer of decisions about the prisoner's release or redetention to the executive. The first requirement that must be satisfied is that according to Article 5.1, the detention must be lawful. That is to say, it must be in accordance with domestic law and not arbitrary. The review under Article 5.4 must then be wide enough to bear on the conditions which are essential for a determination of this issue. Where this decision about the length of the period of detention is made by a court at the close of judicial proceedings, the requirements of 5.1 are satisfied, and the supervision required by Article 5.4 is incorporated in the decision itself. That is the principle which was established in De Wilde, Oons and Versailles. But where the responsibility for decisions about the length of the period of detention is passed by the court to executive, the lawfulness of the detention requires a process which enables the basis for it to be reviewed judicially and at reasonable intervals. This is because there is a risk that the link between continued detention and the original justification for it will be lost as conditions change with the passage of time. If this happens, there is a risk that decisions which are taken by the executive will be arbitrary. That risk is absent where the length of the period of detention is fixed as part of its original decision by the court. So it's submitted that recall for breach of licence in terms of Section 17 engaged 5.4 of the Convention because it fell within the exception to the basic rule described by Lord Hope. And following on Giles, a number of cases referred to by this court in the case of Whiston drew a distinction between the situation where a prisoner was released on discretionary grounds and those prisoners released because of early release provisions and were entitled to be set free. In that second situation, it was held before Whiston that a prisoner who was entitled to be set free and was recalled was entitled to an Article 5.4 review. And I say that in light of the decision in Giles and the correct analysis of the Strasbourg case law in that case, it is submitted that this was the correct approach, as the prisoner had been entitled to be released. The basis of his recall and detention is the risk of offending rather than the original order of the court, and Article 5.4 applies. In the appellant's written case, at pages 21, 22 and 23, I'll get the MS number for that. At 21, 22 and 23, the MS page number is 112 through to 114. And in the written case, reference is made to the case of Clift and Black, in which both cases the court very much identified a step change in relation to the application of Article 5.4 at a stage where the prisoner had passed the point of mandatory release. And just to demonstrate, for example, paragraph 44 of the written case, I make reference to something that Lord Roger of Aylesbury said in Black, which highlights the distinction that he drew between the point at which the sentence had reached. He said, "Is the mere fact that he has reached the halfway stage in his sentence a fresh development which might make his detention unlawful? Plainly not. His detention would not be unlawful after the halfway point, unless the Secretary of State had ordered his release under Section 35, and he'd remain in custody. In fact, however, the Secretary of State has decided that he should not be released, so he remains detained in terms of the original lawful sentences and has no right to be set free. Other things being equal, he will not have a right to be set free until he served 2/3 of his sentence, as Section 32 applies to him. At that point, if he were not released in licence, he would indeed have an Article 5 to have the lawfulness of his detention determined. In English law, he would bring habeas corpus proceedings to secure his release. So without looking at detail in Clift and Black, which I referred to in the written case in detail, it is obvious from these cases and before Whiston that the courts had made a distinction between prisoners and the point of their sentence and the applicability of Article 5.4. Moving on then to what the case of Whiston, which is in Volume 3, tab 26, at MS 1376. In the appellant's written case, it has been respectfully submitted that where Lord Neuberger determined that in relation to determined sentences, Article 5.4 did not apply, that was an arbiter decision in the context of this case, which was looking at a prisoner who had served part of his sentence and had been granted discretionary release on the basis of home curfew. He had not reached the point where there was mandatory release, and so his recall back to prison because of his failure to meet the terms of conditions for curfew was not one that invoked Article 5.4. what this court, what Lord Neuberger went on to do, was to look beyond the question of Article 5.4 in the context of Mr. Whiston's case, and in a broader sense looked at the application of 5.4 to all determinate sentence prisoners. And in her opinion, Lady Hale correctly, in my submission, identified that this aspect of Lord Neuberger's decision, as approved by the other members of the court, was, strictly speaking, obiter, and so not binding in the context of the applicability of Article 5.4 to a prisoner who passed a mandatory point of release. And I would respectfully adopt Lady Hale's decision in this case and her analysis of the jurisprudence from Europe.
Of course, what I said was equally obiter, wasn't it?
It was equally obiter. And
so we are comparing two obiter dicta, and the majority agreed with my lord, and so yes. I have to be suitably modest about the value of my own opinion.
Of course. But what I'm going to submit is that my lady was quite correct.
Thank you.
Because of the jurisprudence from Strasbourg, summarised by Lord Hope in Giles, in the way that he did, in which he recognised that there's exceptions to the general rule where the decision-making process moves from the court to an independent body administering the sentence, and they're concerning purely the question of risk posed by the prisoner. Lady Hale's judgment is at page 1391 through to 1394, and in that judgment, Lady Hale pointed out that there was one case from Strasbourg, the case of Brown, that was one in which would seem to be a case where the Strasbourg court simply said Article 5.4 doesn't apply to a determinate sentence prisoner. At paragraph 53, at page 1392, Lady Hale points out that the court went on to say that the fact that the applicant, before the end of the sentence, may expect to be released on licence doesn't affect this analysis. However, the position in our law is rather stronger than an expectation of release on licence. The prisoner is legally entitled to be released at a certain point in the sentence. That is irrespective of the risk that those responsible for his imprisonment may consider that he poses to the public. In a very real sense, therefore, the sentence imposed by the court as punishment for the offence is half the actual term pronounced by the judge, and indeed the judge has to explain this to him when imposing it. I appreciate, of course, that the judge imposes a sentence which he or she thinks correct, without regard to the right to early release. The whole point of the sentence is intended as punishment. Once released at the 9-month point, the prisoner remains liable to recall for the remainder of the term. However, the reason for his recall could then be subject to scrutiny by the parole board, which will focus on whether or not he poses a risk of reoffending or otherwise endangering the public. Thus, it can be said that once a prisoner has passed the point of mandatory release and licence, the basis for any later recall and detention is the risk of reoffending rather than the original order of the court, and Article 5.4 applies. Lady Hale points out that this distinction is consistent with Giles, and points out that in addition to that, in the cases over the page at 1393, the case of West and Osborne and Weeks were ones in which we're looking at determinate sentences. And at paragraph D, at page MS 1393, Lady Hale said, while I entirely accept that there's no analogy between a determinate and indeterminate sentence so as to require a review while the prisoner is still in prison, the analogy between the recall of a determinate sentence prisoner who's been entitled to be released and the recall of an indeterminate sentence prisoner is much closer. Lady Hale decision by the case in Black.
Again, Ms Bean, can I repeat the request that you speak up?
Yes, it's where the...
I think we're trying to find something to
microphone.
raise the microphone. It's lower than it should be. Maybe that's convenient, but we may find something else to do that. I'm sorry.
It is awkward where it's placed, but that seems better now it's higher.
That is better.
That's much
Yes.
better. That's all right. If it doesn't, maybe you should get another. If there is another lectern or something.
Yes,
That would
I'll
maybe
go with
easier.
this at the moment. I think it'll be... I'll try with this at the moment.
I think they're getting another lectern for you.
All right.
Could I ask you to go back to the previous point, because
Yes.
your voice slipped away and I didn't
Yes.
pick you up.
You were actually quoting the final sentence of paragraph 55, I think.
Yes.
Yes, I was. Where I think my lady explained that while she entirely accepted there's no analogy between determinate and indeterminate sentences so as to require a review while the prisoner is still in prison, the analogy between the recall of a determinate sentence prisoner who is entitled to be released and the recall of an indeterminate sentence prisoner is much closer. Lady Hale makes reference to the case of Black against the Secretary of State for Justice, and in particular to what Lord Brown of Eton under Haywood said there at paragraph 73. Lord Brown's statement at paragraph 73 can be found in the appellant's written case, I think, without actually having to look at paragraph 73. Sorry, I just referred to Lord Phillips of Wortham-Travers and Lord Roger of Elsbury in my written case. But it would be helpful, I think, to look at Black and to paragraph 73, because what Lord Brown said there is important. And so the case of Black is in volume 1, tab 11, at MS 781, and paragraph 73 is at page 817. In there, Lord Brown explained that the central complaint made by Weston Smith was that the parole board had failed to allow them an oral hearing when deciding whether or not to recommend them for re-release after the recall, any such recommendation by the board being binding on the Secretary of State. In seeking to resist their appeals, the board naturally placed considerable reliance on Strasbourg's rejection of Brown's case. The House nevertheless allowed the appeals having regard to the common law duty of procedural fairness and to Article 5.4. Lord Bingham referred to Brown and Ganaskus in part of his opinion, which rejected the appellant's case under 5.1, but not his discussion of 5.4. Rather than that connection, he made no mention of Brown, but instead referred to the Strasbourg decisions of Van Drugenbroek, Weeks, Time, Wilson, Gunnell, and E against Norway, and concluded at paragraph 37, the Convention jurisprudence established that the judicial review of the lawfulness of detention must be wide enough to bear on those conditions which, under the Convention, are essential for the lawful detention of a person in the situation of the particular detainee. Plainly, however, that decision was reached in the very specific context of the recall of prisoners released on licence for breach of their licence conditions. In each case, the appellant had in fact been released automatically after serving the requisite proportion of his sentence, and thus, as Lord Bingham pointed out at paragraph 30, had a statutory right to be free. Although, however, Lord Bingham described this as noteworthy, I do not understand myself the opinions as to whole to suggest that Article 5.4 would call for any different conclusion in the case of those recalled after discretionary rather than automatic release on licence. Lady Hale explains at paragraph 56, MS page 1393, that while she entirely accepts that there's, she goes on to say that paragraph 56, I'm sorry, I now think that this was a distinction which ought to have been given greater prominence, and that is a good reason for holding that their lordships in West were correct in taking the view that Article 4 applied. She said the only case which is not consistent with this analysis is Brown. And Lloyd Norberger is of course correct to say that the decision was based on a fundamental distinction between determinate and indeterminate sentences. But the court appears not to have considered whether there might be a distinction between recall after mandatory and discretionary release. Further, the case had been considered by the Parole Board, which had power to order his release, although this was before West and there had not been an oral hearing. In relation to the case of Brown, I also make reference in my written case to what Lord Phillips of Worthmatrevers said about the admissibility decision in Brown. And in particular, I make reference to this at MS 113, page 113. At paragraph 32, I make reference to the fact that Lord Phillips said that Lord Bingham's opinion in the case of Clift, which I referred to earlier, required particular analysis. And he went on to say the critical question is the point at which the detention of a prisoner becomes or may have become unlawful under domestic law. It's at that point that Article 5.1 may no longer provide justification for the prisoner's detention, and Article 5.4 entitles the prisoner to a judicial challenge of the lawfulness of his continued detention. For most determinate prisoners, it's a halfway point. That is the point at which they're automatically entitled to release. Article 5.4 applies at that point. It's of course satisfied by the right to seek judicial review of the issue of whether the prisoner is entitled to be released. I also made reference to what Lord Phillips said about the case of Brown from the European Court. And I'll just get that. It's at MS page 110, where he too approached the judgment in Brown in the same way that Lady Hale did in the case of Whiston. And he said, if I should read from paragraph 39, this seems to have come close to the court, recognising that there was an issue as to the lawfulness of the applicant's recall. If so, it's hard to see why the court did not accept that Article 5.4 applied to that issue, albeit there was seen no ground for finding that the requirements of 5.4 would not have been satisfied. There was, however, no consideration of the question of whether under our sentencing regime the possibility of release on licence gives rise to rights that are relevant to the lawfulness of detention under a determinate sentence. So I respectfully say, because of the case of Giles and because of the way in which that was interpreted up until the case of Whiston, Lady Hale was quite correct in identifying that for someone in the position of the appellant, Article 5.4 applied on his recall to prison. Understanding that, I would respectfully say that if Article 5.4 applies, the implied ancillary duty, which is relevant to the manner in which the Parole Board complies with the need for Article 5.4 review, the implied ancillary duty that directly arises under Article 5 should equally apply to a prisoner in the position of the appellant. Lord Reid referred to some of the cases that, he didn't refer to cases, but made the point that the European jurisprudence has looked at the need for rehabilitation in sentences, and it is very much a recognised part of the way in which prisons should administer a prisoner's sentence. But that doesn't alleviate the responsibility in terms of the implied ancillary duty. And I'd say that even though that's recognised and put into effect, the need for the implied ancillary duty is there because of the individual rights it gives to a prisoner, and the need for that in the context of a proper and effective review under the Convention in terms of Article 5.4. So I recognise from what the ministers have put in their written case that there is this body of jurisprudence and a recognition of rehabilitation, but that, in my submission, is nothing to the point when it comes to consider whether or not the Article 5.4 implied ancillary duty to facilitate a prisoner's release applies to a prisoner such as the appellant.
Well, the Strasbourg Court seems to have regarded these as two related matters, but capable of being distinguished. One is that if the state is relying on a risk to public safety as justification for continued detention, then it's under an obligation to make available to the prisoner measures which are capable of reducing that risk. That's one. And one could also, I suppose, say that otherwise that the system of review by the Parole Board required by Article 5.4 is liable to become an empty exercise if the Parole Board recommends that various courses be undertaken in order to reduce the risk, and those courses are then not made available to the prisoner. But, distinct from that, the Court is also laying an emphasis on rehabilitation as a general principle applying to all prisoners.
Yes. I see that, but how that is actually put in place in practice must be one in which there are recognised methods by which the prisoner can say, this isn't being done for me, and I'm not being allowed to reduce my risk, and because of that, I'm not able to facilitate my release, and the authorities administering my detention are failing in that implied duty to facilitate my release. Albeit there's a recognition, that doesn't mean that in practice there's not a way in which the prisoner himself, by virtue of the individual right that was identified that he has in terms of Kayam, that he has a manner in which that he can invoke that. So, because it might be that the European jurisprudence identify these issues very rightly, but they might not be put into practice by member states. And so the way in which one ensures that happens is to have an implied duty to facilitate the prisoner's release, which is seen as part of the exercise that relates to the prisoner's review of his detention at a stage where he is detained for the purposes of public protection. So it's all very well to have the principles, but what you need is a working practice that actually enforces those principles. And I see that in this case, it is a case where, given that Article 5.4 arises just because of the stage of his sentence, there's no logical reason as to why the implied ancillary duty as part of Article 5.4 wouldn't apply to him, for the very reason that my Lord Reid has explained, that any review would be an empty exercise, and which my Lord's point underpins why the court did what it did in Kayam, which was to identify this ancillary duty which arose in combination with the right of review. So I now propose to move on to the question of the award of damages that was made by the court. And in my respectful submission, the award of damages in this case is a reasonable one, and this court should not interfere with that award. In looking at the award of damages in this case, it is instructive to remind ourselves of the content of the duty that was described at paragraph 41 of the case, at MS page 1162, tab 20, volume 3 of the authorities, MS 1162.
Yes. Thank you. Yep.
So it begins at paragraph 41,
yes,
where the court set down the content of the duty. And the court explains that on that basis the question arises as to the precise terms and in particular at what precise level the duty should be put. As a matter of domestic public law, complaint may be made in respect of any systemic failure, any failure to make reasonable provision for an individual prisoner so egregious to satisfy the Wednesbury standard of reasonableness, or any failure to apply established policy. The question is whether liability for the breach of Article 5 is similarly limited. In our opinion, it's not. The express rights conferred by Article 5 are individual rights. The ancillary right, which we identify as existing under Article 5, is also a right in favour of each individual prisoner, and its satisfaction or otherwise depends on the particular circumstances of an individual case. In looking at the decision in Khayyam, it's helpful to go back to paragraph 39, where the court explains that the award for damages is for legitimate frustration and anxiety. So that's at page 1162. And it goes on to say this: except in the rarest of cases, it will not be possible to say what might have been the outcome of an opportunity by way of a prison programme which was not provided or was provided late. It will thus not, except in the rarest cases, be possible to establish any prolongation of detention. Such a breach is likely to attract relief similar to that recognised as appropriate under Article 5.4 in frustration anxiety cases where the parole board hearing has been wrongly delayed. We refer to the very full analysis of Strasbourg awards in Sternum, and we note that in some of them the award needed to reflect not only delay but also procedural unfairness. It may be legitimate to infer rather greater frustration in at least some cases when the point of an impending decision, which may be for release, has been arrived at, than at the more speculative early stage of delay in the provision of prison treatment. So, these features being important in the respect of the content of the duty and what the prisoner who's complaining of a failure on the part of the authorities is making, the inner house was provided with a chronology in the case, and this is in the core volume in the Statement of Facts and Issues at MS page 86. And this chronology is helpful in the sense that it provides an easy way of identifying what happened and when. And much has been made of the chronology by all parties in the written submissions, and I wouldn't intend to go through that in any detail, but I would wish to highlight that the appellant was recalled to custody on the 30th of September 2010, and that he was sentenced to 40 days for theft of a motor vehicle thereafter. And then a case conference had been held on the 12th of November, at which it recommended that he be referred for a violence protection programme. And thereafter, on the 8th of December 2010, there was the first hearing of the Extended Sentence Prisoners Tribunal, at which it was decided that the appellant's release would not be directed. And the Parole Board's decision in relation to this is helpful to look at. It says at MS 265, sort of make sure I've got that right, the correct number for that. It's in the appendix.
Yeah, 264, I think.
264. Ah. Yes, it is. Thank you very much, Lord. What I just wanted to highlight from this Parole Board letter, which summarised the reasons for the decision, was that it contains a summary of the Scottish Minister's position and particular advice given to the ministers by the Parole Board. And on page MS 265, the Scottish Minister's position can be seen to be that there's a number of bullet points, but one of them is the continuing need for you to be assessed and undertake further offence-focused work, and you need to be assessed and positively respond over a sustained period to a planned progression to conditions of increased freedoms and responsibilities. And at the conclusion of that Parole Board hearing, the advice given to the Scottish ministers was that the steps that required to be addressed was assessment to participate in the Constructs course and assessment to participate in the Violence Protection Programme. So the Scottish ministers adopted the position that the appellant required to undertake further offence-focused work, and also sought advice from the Parole Board, which also recommended the assessment to participate in these particular courses named. However, what we do know from the chronology is that the courses that the appellant was identified as having to complete were not complete. He was not given access to these until some considerable time later. And going back then to MS page 87, which is the chronology, I would just highlight that in August and September of 2012, the appellant submitted complaints to the prison service because of the fact that he wasn't being given access to the courses that he required. And it's also agreed that the appellant didn't commence the Constructs course until January of 2013 and didn't commence the Care programme until May of 2013. And because of the development of the availability of these programmes and what was available at the prison the appellant was at, he had to undertake both Constructs and Care. And so one can see from the chronology that it was several years, just over 2 years later, that the identified coursework that the appellant had to undertake was only just offered to him, notwithstanding the minister's position at the Parole Board hearing in 2010. So, looking then at the case of Khayyam, at paragraph 49, in this case, the court looked at the complaint of a Mr. Haney at paragraph 49. So that's in volume 3. And I'll just get the MS number.
165.
165, thank you.
Yep.
So just to look quickly at the case, Mr. Haney's complaint and Mr. Massey's complaint, at paragraph 49, the court said, in relation to the question as to whether or not a reasonable opportunity had been given to Mr. Haney to demonstrate that he was no longer a danger, the court looked at the fact that the answer lay in the letter to him from the Secretary of State in June of 2011. And by this letter, the Secretary of State had identified what a reasonable opportunity was for Haney to demonstrate that he was no longer a danger. That is to say, a transfer to open conditions, and adjudged that he should have the opportunity there and then. Unlike the cases of the other complainants, there was no other opportunity which could be afforded to him to demonstrate this. That he did not have this reasonable opportunity was the result of the systemic failures identified in the Walker and James case, and it's clear but for those failures, Haney would have been transferred to open conditions in or about late summer 2011. What he would have made of that opportunity cannot be known, nor can it be known whether the parole board would have adjudged him safe for release and licence, which would endure for the rest of his life. But that he was deprived of the reasonable opportunity which the Secretary of State himself said that he should have is clear. And in that case, in the case of Haney, in looking at paragraph 50 at 1166, it was identified that the delay in transfer was of about a period of a year, and that an appropriate award for Mr. Haney was £500. And in looking at the case of Massey in the same decision, at paragraphs 68 and 69, in Massey, at paragraph 68, the question was also posed whether or not there had been a reasonable opportunity for Massey to rehabilitate himself. And what's clear from Mr. Massey is that he did have a background of having undertaken several courses. What it says is that it was apparent that less than 2.5 years of his tariff, somewhat shortened properly by time spent on remand awaiting trial and sentence, was as well furnished with offender behaviour work as one could reasonably expect. And the court lists all the courses that he was sent on. In paragraph 69, however, the court goes on to say, however, it's important to note that no doubt mindful of the comparative brevity of his tariff, the Secretary of State, by the formal letter of October 2010, effectively defined what was regarded as a reasonable opportunity for Massey to build on the partial progress which he had made and to demonstrate that he was safe to release, namely over a 2-year period. Neither this timetable nor anything approximating to it was honoured. Instead, it was not until after that period had come and gone that he was able to begin with the e-stop. And the letter shows that even if this produced a successful outcome, a further year or thereabouts was contemplated. We conclude that in Massey's case, there was a failure to provide him with a reasonable opportunity to try and demonstrate that he was safe for release, which the Secretary of State regarded as reasonable. The assessment for EOSTP was in spring 2011. If there had been a plentiful supply of places, he might have been able to be on that by autumn of that year. But no real complaint could have been made merely because this kind of course was not immediately available. If it had been provided in or about spring 2012, there would, we conclude, have been no breach. There is thus an unacceptable delay of about a year, and all post-tariff. The inference of legitimate frustration is justified, and the period calls for an award of damages. And post-tariff, this was assessed at £600.
As I understand it, is this right, Ms. Bain? You are, as it were, content with the £500,
yes,
although you say it's low. The first respondent, Scottish ministers, are content as well.
Yes.
But the Advocate General says it should be nothing or in the alternative
yes.
250.
Yes, that's right. But I say it's within the reasonable band of awards that the court would make.
And you have the comfort of knowing the Scottish ministers aren't challenging that.
Yes, but what I think is important to recognise is that in their responses, both the ministers and the Advocate General criticised the fact that any award was made and focused very much on what the European Court of Human Rights said when the case of Khayyam went to the European Court. And because at that stage the European Court took a very different view as to whether or not an award should be made. And I think it's important to recognise that at paragraph 72 of the European Court's decision in Khayyam, that the Court continued to approach the way in which the question of arbitrary detention and the need for and the breach of Article 5.1 remain very much as it was when they decided James, and they have a very different and stringent approach to the question of damages in the European Court. And I think it's helpful just quickly to look at that case. It's in Volume 5, tab 45, paragraph 72, MS number 1760. Paragraph 72 is where the court deals with the question of the award.
Sorry, paragraph, I beg your pardon.
Paragraph 72.
Thank you so much. Yes, I see.
MS 1760.
Thank you.
And I think what we'll come to see is that really they're talking about two different things here. It says it's not the role of this court to determine in the abstract whether the UK has properly implemented the judgment in James within its domestic legal order. This is primarily a matter for the Committee of Ministers in their exercise of its jurisdiction under Article 46.2. It goes on to say this court's role is confined to determining whether delays in the provision of rehabilitative courses to the present applicants were such as to introduce a degree of disproportionality leading to arbitrariness as understood by James, and thus rendering the relevant periods of detention unlawful within the meaning of Article 5.1. In making this assessment, this court cannot examine specific periods of delay in a vacuum. It must view any period of delay in light of the detention as a whole and the specific factors identified in its case law. The fact that a delay occurred, even where that delay was at odds with what the Secretary of State had indicated as reasonable opportunity to try and demonstrate safety for release, is not sufficient to meet the threshold required for the establishment of arbitrariness in breach of Article 5.1 of the Convention under James. In this sense, the test applied by this court to whether a violation has been made out in cases concerning delayed access to rehabilitative courses might be said to be more stringent than the approach applied by the Supreme Court to whether a breach of ancillary duty, which read into Article 5 to facilitate the progress of IPP prisoners towards release by appropriate courses and facilities, has been demonstrated. So the court here recognises that it's looking at levels of award in a very different context, and one in which the court would have to conclude that the detention had fallen into unlawfulness, which is quite different to the implied ancillary duty that was identified by this court in Kayam. So I say that this is really of no assistance when this court comes to identify the levels of award, and that the case of Sternum, which so very much examined all of the relevant case law and looked at all the relevant levels of damages, is where we should look. And that's very much the approach that the court took in Kayam in dealing with the levels of award that were made for Mr. Massey and Mr. Haney, the examples that I identify from that case.
Thank you. Yes.
So what I then submit then is that this court should hold that in the critical period after Mr. Brown's return to custody, the appellant's return to custody, and before he was released at the end of his sentence, the Scottish Prison Service failed to adhere to the management plan that was set out for a period of 2 years, and that the Inner House, in allowing 8 months to assess and organise coursework and conclude that the breach covered 18 months of the total period of 26 months between the date when it was first recommended the appellant be assessed for the Constructs course and him starting that course, was a very reasonable way for them to have approached matters. The respondents suggest that there's a complication in relation to the damages in this case, and they say that that's because the bulk of the period of delay fell within this custodial term of the extended sentence. And I would say that is not a complication, because the appellant was recalled following on mandatory release, and he would only have ever been released at the stage at which he demonstrated his risk was at a level acceptable by the parole board. And I say that the duty, implied ancillary duty, applies on recall, not at the stage where the custodial part ends and the extended period starts, because of the way in which this sentence is administered by the parole board. There's no need for that added complication to be put into the mix when this court is assessing the level of award. It's a complication that actually is without any merit because of what I've explained before in relation to my position about when the duty arises, which is on recall following mandatory release.
It's a rather odd exercise, this, because Section 8 of the Human Rights Act requires the court here to apply the principles that would be applied by the European Court. We know the European Court doesn't adopt this ancillary duty under Article 5.4 analysis at all. It deals with it under 5.1a.
Yes.
And it treats 5.1a as the appropriate provision, but one which imposes a more stringent test than the ancillary duty that that this court led into, Article 5.4 in Cayam.
Yes.
And the consequence of that is that this court could find itself making awards of damages, or indeed the inner house could find itself making awards in circumstances where the Strasbourg court would make no award because it would find no breach.
They would find no breach for a reason that would be quite different to the way in which this court has said that domestically we should incorporate the decision-making of the European Court. So this court has taken on all the factors that were relevant to the decision in James and sought to apply them sensibly and I would respectfully say appropriately, because it's inappropriate to look at a sentence and to consider whether it lapses in and out of lawfulness. So up until such time as this court changes its position in light of the decision by the European Court in Cayam and revisits this issue, I say that they should apply the reasoning and approach of the court in the case of Cayam.
Even if that means we're awarding damages for a breach of convention rights in circumstances where the European Court would not find the breach.
Because of the difference in which, the different way in which the law has been brought into effect in this country.
I suppose we can look and say, if, as a result of a different analysis, the Strasbourg Court would have found that this particular loss was suffered, whether under 5.1a, 5.4 or something else, or different circumstances, what sort of damages, what sort of compensation would they have awarded for this sort of disadvantage, this sort of loss?
Yes. So that,
but I suspect their views may be coloured by the precise convention right that has been breached.
And the breach of
duty.
duty.
But we have to do, as we say when all else fails, we have to do the best we can.
Yes, and that was something that was very much discussed in Cayam, where the court identified what it did, for example, in the case of Horncastle.
Yes.
That's the approach that this court should take in taking into account the jurisprudence from Europe, but also applying it in a way that makes sense.
Well, Strasbourg and this court have a dialogue on various issues, and I hope we listen to each other, and sometimes we persuade them, and sometimes they persuade us.
But has Strasbourg, the Strasbourg case, especially the Cayam one, everybody was complaining that the detention was unlawful.
Exactly.
Yes.
Strasbourg then acknowledged that, of course, the Supreme Court had said, no, detention isn't unlawful, but there is this ancillary duty. Do they at any point say that we were wrong to do that?
No, they don't.
No. So there is no Strasbourg case which has actually examined the question that we have before us, and as to what the appropriate solution might be.
Yes.
So they don't say it's wrong.
It's
just not what they do, because the complaint was as the unlawfulness of the detention.
It was an admissibility decision as well, so they wouldn't have probably gone very far on that.
So, for the reasons that I advanced in my oral submissions and for the reasons set out in my written argument, I move the appeal in the way that I've set down.
Thank you very much indeed, Ms. Bain. Thank you. Mr. Layton.
Nothing to add.
Thank you very much. Mr. Moynihan, there may be a bit of housekeeping rearrangement. Take your time, don't worry. Why not?
That seems as if I'm not a very good furniture remover. So
maybe that the other speaker should be moved away. Perhaps, maybe getting some feedback on that. Yes, sorry.
So Khayyam in Strasbourg, I suggest, is of critical importance in understanding the existence of the duty. It is plainly relevant to the question of breach. And I should say this for the avoidance of doubt, as my Lord in the chair has already observed, I wish to say nothing of quantum. One would wonder why 4 parties with 8 counsel are here to argue about whether the sum should be £250 or £500.
Well, it's not the only reason you're here. And,
thankfully.
And also, I suppose, there could be a knock-on effect in other cases.
Well, if I may respectfully say so, my Lord, the difference, and there is no difference between my position and that, as I understand it, my learned friend, the Advocate General. The issue in relation to quantum, if one may call it that, yes, is in fact an issue of principle. And it is the question, at what point does the ancillary duty begin to apply? If, as my learned friend Miss Bain says, the ancillary duty applies at the date of recall, that is in September 2010, then the delay is in excess of 2 years. If the ancillary duty applies at the date when the custodial term ends and the extension period begins, that date is August 2012. And accordingly, the delay period is something just a little short of 6 months, for which, applying the analysis of my Lord Reid in Stirling, the appropriate award for 6 months in Stirling was £300. So that is the issue of principle. And in fact, I engaged that issue of principle at an earlier point in the argument. and I apologise, I've not carried it through to issue number 3. If I felt if I'd lost by issue number 2, then it was perhaps either academic, or if I'd lost on the more fundamental point that the date begins at recall, what the Inner House said for quantum was correct. So I don't wish it to be an issue of quantum, but I will take up the issue of principle.
Thank you.
If I can address the court in this way, I recently had the privilege to reread a case that's otherwise irrelevant to this. This is the Home Office in Dorset Yacht. And I mention that just in passing, of course, because it's the other side. Lord, I reread it because of a case called Thompson against Scottish ministers, where, among other things, I was scolded for referring to too many authorities in the Inner House, as my Lord may recall. The point about it is, of course, it's the opposite side of this case. It's speaking of reformation. It's 1970, reformation of prisoners. And, of course, the duty of prison authorities to the general public, where, in the act of rehabilitation or reformation, Borstal boys were taken to an island in Poole Harbour for work experience, and as we know, it did what was natural, and mayhem ensued. I mention it for two reasons. First of all, in looking at the nature of the duty, Lord Diplock begins with the proposition that, laudable though it is, sadly, reformation of prisoners doesn't always succeed. Hence, we are talking here of giving an opportunity, not a guarantee of rehabilitation. But what's much more important, and I wouldn't have mentioned it save for this, Lord Diplock's speech in Dorset Yacht, which I've not brought, it's 1970 appeal cases, is one of those rare situations in which a member of the judiciary discusses the judiciary's lawmaking function, more or less large, depending on the nature of the case. And it's my submission that we are looking at this court's, and indeed courts in plural, the lower courts as well, lawmaking function. For the very reason the conversation ended with my learned friend Miss Spain, it's my submission that we are now looking at a situation in which the ancillary duty is being relied upon in circumstances in which it is beyond peradventure that Strasbourg would say there is no breach of 5.1a or 5.4. Is it the intent of this court that the ancillary duty should be of that reach? Now, Lord Diplock simply put it in this way, and it is forgive me, it is simplistic, in particular to this court. But what he said was, of course, in the lawmaking function, the court can be involved in issues of the public interest, which is what this case concerns. And more importantly, what his lordship said was, in deciding whether to extend the law, judges pay greater attention to the decisions in individual cases rather than to the reasoning, because the reasoning can be broader or narrower as circumstances permit. So the example he gave was of one of the most famous, in fact, probably the most famous dictum, that of Lord Atkins in Donoghue against Stevenson. Who is my neighbour? The answer, someone I can reasonably contemplate will be directly affected by my acts. Is that the test for the law of negligence? The answer is no, it is not. But it is a central part of the reasoning in the case. So it is, in my respectful submission, in the present case, critical that one analyses the decisions. If I may, with respect, pick up a point that Lord Reid has asked. In my written case, I acknowledge that the Strasbourg court, and I acknowledge it in Grand Chamber decisions, Hutchinson being the most recent, but that Murray I cite because it's got the longer discussion. The Strasbourg case has increasingly, over the years, spoken more of rehabilitation of offenders as a core part. And indeed, in Murray, the Grand Chamber itself says it's an increasing part of the court's jurisprudence. I have not found a single case in which that recognition of the importance of rehabilitation has been applied as a positive obligation on the state in anything other than an indeterminate sentence. Life, and Murray is of course a Dutch case concerning whole life tariff, whole life sentence. Life, and in James, indeterminate sentences for public protection. And it is salutary, in my submission, this is where we come back to the question of whether this court intends the ancillary duty to reach beyond what the Strasbourg court is doing. In every case subsequent to James that has gone back to Strasbourg, including Kayam, the court has found no breach of Article 5.1a, including Mr. Massey, who was one of the individuals who succeeded in Kayam. I mentioned, and I don't wish to turn them up, I think we've already put in too many authorities in this case, given some of the recent guidance from this court. But I mentioned at least 4 cases in paragraph 40. I missed one. So.
Are you suggesting that this court should depart from the decision of this court in Kayam?
No, my lady.
Which
No.
constructed the ancillary duty.
No.
You're not suggesting we should do that.
No, my
That's a
lady.
relief because there are only 5 of us present.
But
Simply confine it to.
But
to its
simply confine it to
circumstances.
its
confine it to its circumstances.
Of course,
That is
it's
correct.
very interesting. I'm sure you're going to take us to these authorities, but a lot of the recent authorities, like Hutchinson and Vinter, were about whole life
Yes.
tax.
two, 1 2, 1 2, 1 2, 1 2. One, two. One, 1 2, 1 2, 1 2, 1 2, 2 2 2 2 2. One, two, 1 2.
Yeah, it's red now, so.
Right now.
I was going to say that I'm going to try to avoid some of these sort of definitional issues, because in fact, as befits the discussion in Whiston, some of these definitional issues are very difficult and indeed conflicting, and one has to be careful of the context in which the definitions have been displayed. If I can make an important point in relation to that, my learned friend argues that there's a difference in principle between an extended sentence on the one hand and a determinate sentence on the other, because an extended sentence has both a custodial term and an extension period. And she relies on the case of Sim, to which I refer in my written case, and I must acknowledge that the reference comes from the learned friend, the Advocate General, so it benefits from the English experience. But what's important is, in the case of Sim, the Court of Appeal drew a distinction between the custodial term and the extension period. So in our case, the line would be drawn at August 2012, not September 2010. And therefore, my learned friend, for her reasons, and for her argument, has in fact to submit that Sim is wrongly decided. And my learned friend goes further and submits that what is important is that the recall and detention following recall of an extended sentence prisoner is solely determined by risk. And in terms of the statute, that is correct. And if I may, and I do this next part with considerable trepidation, if I may put my nose only across the border and draw the Court's attention to something that my Lord Neuberger mentioned in the case of Whiston, which is in Volume 3, tab 26. It's paragraph 9, it's MS page 1381. My Lord in the Chair, it was surveying the legislation, and as I understand it, referred to the Criminal Justice Act 2003, in particular what was then Section 255C, and your Lordships will see at paragraph 9, my Lord begins, first, Section 254(1) of the 2003 Act gives the Secretary of State a general power to revoke any licence and to recall the licensee to prison. So I understand your Lordship to be referring to the generality of prisoners, not extended or lifers. Where the power of revocation is exercised under Section 2541 and the licensee is entitled, pursuant to Section 2542, to be told the reasons for his recall and to make representations to the Secretary of State, who can cancel the revocation of the licence under 2542A. Sections 255A to 255C contain provisions which apply when a licence is revoked under 2541 and the revocation is not cancelled. And it's this, lady, that I now refer to. Your Lordship says, in general terms, in such an event, the Secretary of State may release the former licensee if satisfied that he will not present a risk of serious harm to members of the public. So that is the same test as we encounter for lifers and extended sentence prisoners in Scotland. It is part of the general architecture of parole, as I would understand it in England. And as I say, I put simply my nose across the border, because I've said in my written case, I don't wish to get caught up in sentencing policy in England because I frankly know nothing of it. But it is that particular paragraph that leads us to say that in fact on this analysis, following the reasoning, we would arrive at the situation that the ancillary duty applies to every prisoner. Now, again, let me stand back. It is, as one would expect, a central part of penal policy throughout these lands that there is an emphasis on offering rehabilitation. The object is, a part of the object, in addition to punishment and deterrence, part of the object is to protect the public. So you will not hear me saying that the Scottish Prison Service doesn't have an emphasis on rehabilitation. The question here is, to what extent is that the subject of the ancillary duty that this court recognised? Now, it's that brings me to the point of asking this court to be careful and mindful of the different issues that arise on analysis. We have 5.1, Article 5.1, that I will look at shortly. We have Article 5.4. We have the ancillary duty. We have the duty that's in the case law referred to as the public law duty in relation to the governments properly implementing their policies for penal servitude and the likes. And of course, the public law duty has been found to be breached in a series of cases, including James and Cayenne. So it's not an empty vessel. As we know, and indeed, if I may mention this, reference is made to international law. And the international law that's mentioned in the cases is Article 10 of the International Covenant on Civil and Political Rights. One can turn that up in James. But Article 10 makes rehabilitation a general feature of penal policy. So the sort of subtle distinctions that my learned friend is drawing are not supported by some of these broader sources. One knows, to use a metaphor, that, as is often said, different streams, the European Convention on Human Rights, EU law, different courses flow into the same stream and become part of the same body of law. But on occasion, in some sections of the course of a river, one source will dominate more than another in adding force to the stream. And I make this point in relation to 5.1, in particular 5.1a. As my learned friend has pointed out, in particular in an exchange with Milady Hale, Strasbourg adheres to the position that rehabilitation of offenders is to be considered under Article 5.1a. Now, if I may digress, consideration has been given to 5.1a by this court, in particular in Stirling, in the context of a delay in a hearing by the Parole Board. And of course, what was held in Stirling was a delay in a hearing before the Parole Board can be and will be a breach of Article 5.4, hence the remedy and damages. But Lord Reid in particular, with it's paragraph 13, I won't turn it up.
Thank you.
But in the summary of his conclusion for the court, pointed out that it's only in exceptional circumstances that such a delay would amount to a breach of 5.1a. Now, Stirling, an exceptional breach being required for 5.1a in the context of the Parole Board, entirely matches and is consistent with Kayam in Strasbourg, because in Kayam in Strasbourg, it's either paragraph 70 or 72, if you forgive me again, I won't delay the court by turning it up. The point is made by the Strasbourg court that a breach of 5.1a will only be in rare circumstances. And they stressed that the claimants in James, three of them, James, Wells and Lee, there had been no efforts whatsoever to progress their rehabilitation in the early years. And indeed, their tariffs expired before any progression to rehabilitation. It was in that extreme situation. So this court in Stirling and Strasbourg in Kayam are at one. 5.1a is an extreme situation. If I may, in particular, pick up a point that Lady Hale was asking me, if I can give this sort of expression of what happened in James. It was, in effect, the government applied a lock to the door, but simply didn't purchase enough keys. That's the definition of an arbitrary detention. If you're told you can be let out, but no one's yet got the key, that is arbitrary detention, and that's the extreme situation. We will see, and there are 5 cases mentioned, and this court discussed some of them in Kayam. But I mentioned one of them, and I'll come to it a little later when we look at breach. Case of Alexander. In Alexander, it's a sex offender. It was like Robinson in Kayam. It's the extended sex offender treatment program. A 4-year delay. 4-year delay. 2 years pre-tariff. 2 years post-tariff. 4-year delay. No breach of Article 5.1a, because detention had to be looked at as a whole, and Mr. Alexander had had some courses. And of course, Mr. Brown has had some courses prior to release. The constructs course, which is the source of the problem here, he had actually undertaken. So it's a question of repeating. So that is why, if I may, I do wish to be assertive and simply say that it's beyond peradventure in Mr. Brown's case that there will be no finding of a breach of 5.1a. Because what has been done, again, the cases speak of this. One should not look at any one period in a vacuum. This court, in fact, is asked to do exactly that, to look at December 2010 to January 2013. Why December? December 2010 is the date when the Parole Board recommended access to the constructs and violence protection programme. But my learned friend closes her eyes in the written case to what had happened before release for Mr. Brown, and indeed what happened afterwards. He underwent constructs, he underwent care afterwards. As the Inner House said, his performance was not very good. And he was not released, not due to absence of rehabilitation, simply because of his own behaviour in prison. So, in my submission, it is important that this court begin, in fact, by the proposition that is here no breach of 5.1a. There cannot be. There is also no suggestion of a breach of 5.4, Article 5.4, because there are regular reviews in Scotland, and we need not worry about whether Sim is correct or not, or indeed in relation to the case of Twiston, whether the Lord in the Chair for the majority or Lady Hale is correct in the reasoning. Why? Because as a matter of general law in Scotland, and I've set out the provisions, the Parole Board is engaged in cases where individuals are recalled in any category. So we've not, in fashioning the legislation, we have not tried to follow the perhaps shifting sands of Strasbourg. And why should we? As this court has on a number of occasions stressed, human rights didn't come into existence in 1998. We have the common law, and of course the Human Rights Act has influenced it, but doesn't solely determine these cases. There is no breach, in my respectful submission, of 5.4. Looking at the, and I may also say, before coming back to the ancillary duty, there is no suggestion here of a breach of any common law provision. There's no public law duty said to have been breached. There is no case made under the International Covenant on Civil and Political Rights. We are simply looking at the ancillary duty. And if I may say this, this is central. In Cayenne, this court considered the question whether it should apply or follow James. And there was the consistent reference to ULA and to my Lord and the Chair's formulation in Pinnock, and indeed to Lord Mance. In what circumstances will this court follow Strasbourg? In some instances, in which will this court get ahead of Strasbourg? And in some instances, this court will await Strasbourg. In my respectful submission, what can be said about this court in Cayenne, reflecting again the analysis of this court in Corrie, there were reservations about whether the James decision should be applied, because it resulted in fluctuations between lawful and unlawful detention. The court referred to the ULA principle, and what, in my respectful submission, this court decided to do was to give effect to the decision. Again, coming back to Lord Diplock in the Dorset Yacht, give effect to the decision in James, but with reasoning that qualified the practical effect of James, so that the remedy was one that was commensurate with our legislation. So individuals who remained a danger to the public would not be released, but there would be a remedy in damages, and indeed, to use the English terminology in Cayenne, the prospect of a mandatory order. So that a remedy was given for the wrong that was identified in in James. But it's my respectful submission that it cannot be taken from the approach of this court in Cayenne that the intention was to get ahead of Strasbourg or to create an independent common law right. In some circumstances, one thinks of the Parole Board and fair hearings where this court has said we will develop the law independently of Strasbourg. Cayenne is not such a case.
Perhaps a way, or perhaps something has to be borne in mind in trying to avoid inconsistency between our approach and the Strasbourg approach might be this, that although the ancillary duty has been found to facilitate progress towards release by providing appropriate courses and so forth, has been said to arise under Article 5.4, and I would have thought, subject to your arguments to the contrary, which we may come to, might be thought to arise from a stage where a prisoner's release depends on assessments of the risk he presents to public safety. It's still a duty that has to be applied by the courts in a realistic way.
Yes.
I mean, obviously there are limits to the extent to which courses can be made available, and some delays are going to be inherent in any system. And just as the Strasbourg Court imposes quite a high test before it finds a breach of Article 5.1a, I wouldn't have thought domestic courts would rush into finding breaches of Article 5.4 whenever there had been some delay in providing a course.
If I may respectfully say so, I agree, my Lord, and if I may say this, developing that, there is of course a difference on the facts in Massey between this court in Cayenne and Strasbourg. As far as I can discern, the two courts were in fact applying the same test. Why would they not be? Because this court considered the test applied in James, and all there was a difference in threshold or tolerance. Exactly the sort of thing that can occur if two different decision makers each applies his own mind separately to the same facts. The problem, and it comes to this, my Lord, if I engage with the very point Lord Reid has made, why do I argue so much about the question of duty? Why not just concentrate on the second question, there was no breach in fact in this case? The point is, and it's put in pejorative terms in my written case intending to challenge, is if the duty is recognised, the concern is there will be a conveyor belt of claims. That can have, as we see here, just simply the very fact that these cases are litigated with factual decisions to be reached by the court about whether the threshold is breached in one case or another, can have a very significant cost to the public purse. Prisoners are almost inevitably going to be on legal aid. Scottish ministers are public funds, and one doesn't imagine in the routine cases that those to my left would be there. But the concern is that an unnecessary recognition of a duty will lead to litigation and public expense without the real benefit that Article 5 is intended to promote. And why do I say that? In Mr. Brown's case, his petition for judicial review commenced after he had begun again the constructs course. By the stage it reached the inner house, he was a matter of months short of having completed his extended sentence. This case was not one that was had any realistic prospect of forcing the ministers to get off their seats and take action. They had taken action by the stage this was reached. This is one of those cases which is simply, and hence the reference to the conveyor belt, a claim for damages for what is an historical breach. And that is why I started with Lord Diplock to ask, is it in the public interest that a duty of that sort be recognised? In James, there was a high public interest because the government had introduced a sentence that presupposed the availability of rehabilitation and, in the words of judges, had deplorably failed on a systemic basis to make the resources available. There was a high public interest. And it's my respectful submission that that high public interest is missing. In addition, because in this court the sole remedy is not damages, there's also a question of mandatory orders. I have to be careful. There's some discussion about exactly what mandatory order is envisaged. I think it's Lord Brown thought that it would be a declaratory order and not what we in Scotland would call specific implement. In other words, because the court couldn't necessarily fashion a precise order as to what the executive required to do. But Scottish Prison Service envisages a situation in which, for example, in Mr. Brown's case, where he's waiting for the constructs course, that the mandatory order would be an order for specific implement to ordain ministers to place Mr. Brown higher up, indeed at the top of the list for any particular course. And then that runs the risk that the beneficiary, Mr. Brown, has a judicial invitation to a course, necessarily at the expense of someone else. So to take, not the whole life as determined, to take another example, there are individuals sentenced to perhaps 20 years on a determinate basis. Parole is available after 10 years. They get mandatory release, or they did get mandatory release based on 2/3 of the sentence. That's after 16 and a half years. Now, the discount under our legislation is 6 months. So those individuals face the prospect of being detained for 19 and a half years. Between year 10 and 19 and a half, their release is dependent on the risk assessment by the parole board. The import of my learned friend's argument is that Mr. Brown in his extended sentence gets priority over an individual serving a determinate sentence, even of that duration. And what would happen would be that the court would say, Scottish Prison Service is wrong to prioritise Mr. Brown below an individual serving 20 years because Mr. Brown is in principle serving a different type of sentence. That would bring about an unjust result. It is not appropriate to try to draw subtle distinctions based on precise categories of sentence.
If nowadays determinate sentences mean mandatory release, for example, 20-year sentence means mandatory release after 19 and a half, discretionary release after 10, so 9.5 years in custody depends on an assessment by the parole board of risk. The ancillary duty under Article 5.4 not then apply to that?
Well, certainly, and this is where I make the point. I'm not trying to look at this in isolation. Common law would apply. So if someone is being held under those circumstances and there is an adequate provision, that is where the public law duty would kick in. So one is trying to add in this ancillary duty on top of other layers. And the question is, again coming back to Lord Diplock, in the public interest, what does this ancillary duty add to the mix? And in my respectful submission, save for the extreme, an extreme is Lord in Stirnham, or the rare, which is the Strasbourg case in Kayam, it's not intended to add because of the risk that it will create the very mischief the court acknowledges it should not engage in, of the court micromanaging the availability of...
The court wouldn't be micromanaging, but it might be finding that the ministers were failing to make available a sufficient... The effect of a court's decision would be the Scottish ministers would have to devote more resources to making courts available.
Yes. But I'm aware of the time.
Yes.
If that's appropriate to...
I think that would be a convenient moment. Thank you very much. We'll resume again at 2:00. Court's now adjourned.